Question number 951. There shall be no appeal by convicted in the following. Option A, where a magistrate of first class passes only a sentence of fine not exceeding 100 rupees, where a court of session passes only a sentence of imprisonment for a term not exceeding 3 months, where a high court passes only a sentence of imprisonment for a term not exceeding 6 months, all of these. Here correct answer is option D, that is all of these. Question number 952. The provisions regarding abatement of appeals are contained in dash of the Code of Criminal Procedure 1973. Here correct answer is option D, that is section 393. Question number 953. For the purpose of grant to leave to appeal under section 394 of CrPC, the term near relative does not mean option A, lineal descendant, brother, uncle, wife separated under the decree section 125 of CrPC was applicable to all. In question number 953, correct answer is option C, that is uncle. Question number 954. Appeal from subject match the list. List first is subject matter and list second is sections of CrPC. Appeal from convictions. Correct answer is section 374. No appeals in petty cases. Correct answer here is section 376. Appeals in cases of acquittal. Correct answer is section 378. And last, no appeals in certain cases when accused pleads guilty. Correct answer is section 375. By going through these codes, the correct answer option here will be option C. Question number 955. Under which section of CrPC the provision for reference to High Court is given? Reference to High Court is given under section 395 of CrPC. Question number 956. Under CrPC, a reference can be made to Supreme Court, High Court, Session Court, High Court or Session Court. Correct answer is option B, that is High Court. Question number 957. A pending case is referred for opinion under section 395 of CrPC 1973 to the Chief Judicial Magistrate, Supreme Court, High Court, Court of Session. Correct answer here is option C, that is High Court. Question number 958. Which of the following provisions deals with the power of session judge of revision? Option A, section 401, option B, section 400A, option C, section 402 and D, section 399 CrPC. Correct answer is option D, that is section 399 of CrPC. Question number 959. When the High Court or any session judge calls for to examine the record of any proceeding before inferior criminal court, it is known as, correct answer is option C, that is revision. Question number 960. Which of the following sections of the CrPC imposes a ban on using revisional power against an interlocutory order? Correct answer is option B, that is section 397 clause 2 of CrPC. Question number 961. Which of the following sections of CrPC deals with the High Court's power of revision? Here correct answer is option B, that is section 401 CrPC. Question number 962. While exercising the power of revision under the Code of Criminal Procedure, the High Court cannot, option A, discharge the accused, option B, acquit the accused, option C, grant bail to the accused, and option D, convert a finding of acquittal into one of the conviction. Here option D is the correct answer because High Court cannot convert a finding of acquittal into one of the conviction. Now let us proceed to question number 963. Question number 963. Which one of the following is not correctly matched? Option A, reference to High Court, section 395. Option B, High Court's power of revision, section 401. Abatement of appeal, section 393. Appeals from conviction, section 374. Here in this question, it has been asked which of the following is not correctly matched. Here correct answer will be option C. Abatement of appeal, section 393 is incorrect. Question number 964. Which of the following combinations are not correctly matched? Option A, anticipatory bail, section 437 CrPC, summary dismissal, section 384 CrPC, appeals in cases of acquittal, section 376 CrPC, reference to High Court, section 397 of CrPC. Here the correct answers here the codes are A1, B2 and D4, A1, C3 and D4, option C, A1, B2 and C3, and option D, B2, C3 and D4. In question number 964, correct answer is option B, that is A1, C3 and D4. Question number 965. The power of Supreme Court to transfer criminal cases and appeals from one High Court to another High Court is conferred under, here correct answer is option B, that is 406 of CrPC. Question number 966. The High Court can transfer cases and appeals. Option A, a fair and impartial trial cannot be held in a particular court. Option B, when some question of law of public importance is likely to arise. Option C, the transfer would be for the general convenience of the parties. And option D, all of the above. Correct answer here is option D, that is all of the above. Question number 967. If a woman sentenced to death is found to be pregnant, the High Court shall. Here correct answer is option C, that is commute the sentence to imprisonment for life. Question number 968. The power of Supreme Court to transfer cases and appeals from one High Court to another High Court can be exercised on an application by which one of the following? Option A, Registrar of the concerned High Court. Option B, Attorney General of India and Advocate General. Option C, Chairperson of the Bar Council of India. And option D, Solicitor General of India. Correct answer is option B, that is Attorney General of India and Advocate General. Question number 969. The process of compulsory stoppage of proceedings before a trial court on the plea of transfer of case from that court to some other court is done away under the provision. Option A, section 407 of CrPC, section 397 clause 2 of CrPC, section 167 of CrPC, section 111 clause 6 of CrPC. Correct answer is option A, that is section 407 of CrPC. Question number 970. When the prisoner is to be confined in a jail, the warrant shall be lodged with district magistrate, jailer, public prosecutor, office of the court. Correct answer is option B, that is jailer. Question number 971. Which provision of CrPC deals with the power of sessions judge to transfer cases and appeals? Option A, section 408, option B, section 409, option C, section 406, option D, section 407. Correct answer is option A, that is section 408 CrPC. Question number 972. Which of the following has the power to withdraw a case under section 409 of CrPC? Here correct answer is option D, that is Court of Session. Question number 973. Which one of the following court is not empowered to transfer criminal cases? Option A, Supreme Court, High Court, Court of Session, the Court of Special Magistrate. Correct answer here is option D, the Court of Special Magistrate is not empowered to transfer criminal cases. Question number 974. When a criminal case is transferred from one state to another, the appropriate mechanism is that the transferor must appoint public prosecutor, that the transferee state appoints public prosecutor, that the complainant exercise his or her choice, either of the two transfers or transferee state appoint public prosecutor. Here correct answer is option B, that the transferee states appoints public prosecutor. Question number 975. Who shall cause the sentence to be carried into effect when a sentence of death is passed by the High Court in appeal? Here correct answer is option C, that is Court of Session. Question number 976. Which section of the CrPC has dealt with the power of High Court to commute the sentence of pregnant woman? Correct answer is option A, that is section 416 CrPC. Question number 977. If a woman sentenced to death is found to be pregnant, her sentence shall be commuted to imprisonment for life by the. Correct answer is option C, that is High Court. Question number 978. Which section of the CrPC deals with the period of detention undergone by the accused to be set off against the sentence of imprisonment? Correct answer is option D, that is section 428 CrPC. Question number 979. Whether sentence awarded in default of payment of fine can be set off under section 428 CrPC? Here options are yes, no, half can be set off, 1/4 can be set off. Correct answer is option B, that is no. Question number 980. Under section 428, the period of detention undergone by a convict cannot be set off during. Option A, investigation of the case, option B, trial of the case, option C, inquiry of the case, and option D, another case. Correct answer here is option D, that is another case. Question number 981. Section 428 CrPC provides for concession to the effect that period for detention undergone by the accused be set off. Option A, against the substantive period of imprisonment awarded. Here option A is the right answer. Question number 982. The sentence of an imprisonment for a term is not set off against period of detention undergone by the person during the trial of the same case when such a sentence is for the offence of rape, is for sedition, is in default of payment of fine, none of the above. Here correct answer is option C, that is in default of payment of fine. Question number 983. Under section 482 of CrPC, which of the following period of detention undergone by the accused shall be set off against the sentence of imprisonment in a case? Here options are option A, period of detention undergone in default of payment of fine. Option B, period of detention undergone during the investigation trial of that case. Option C, period of detention undergone during the investigation trial of similar case, all of the above. Here correct answer is option B, that is period of detention undergone during investigation and trial of that case. Option B is the right answer. Question number 984. All person convicted for life imprisonment for offence of under section 302 of IPC, the appropriate government may commute the sentence for the minimum period of, here correct answer is option C, that is 14 years. Question number 985. Which of the following statements is correct? When a sentence of death has been commuted under section 433 to life imprisonment, such person shall not be released for prison unless he has undergone the imprisonment for option A 20 years, option B 14 years, option C 12 years and option D 10 years. Correct answer here is option B 14 years. Question number 986. Power to suspend or remit sentences lies under CrPC with High Court, Trial Court, Supreme Court, appropriate government. Correct answer is option D, that is appropriate government. Question number 987. In cases referred to in section 433A, the period of detention shall be set off against the period of dash years referred to in the section. Here correct answer is option A, that is 14 years referred to in the section. Question number 988. Who can commute the sentence of imprisonment for life under the CrPC? Option A, that is the appropriate government, is the correct answer. Question number 989. Who has the power to commute a sentence under section 433 of CrPC? Option A, Supreme Court, option B, President of India, option C, High Court and option D, appropriate government. Correct answer here is option D, that is appropriate government. Question number 990. The case of Dina versus Union of India relates to capital punishment, hanging as a mode of execution, long delay in execution of death sentence and head cuffing. Here correct answer is option B, that is hanging as a mode of execution. Question number 991. Under the CrPC, every warrant for execution of a sentence may be issued by the judge or magistrate, successor in office, either by the judge or magistrate who passed the sentence or his successor in office, all of the above. Here correct answer is option C, that is either by judge or magistrate who passed the sentence or his successor in office. C is the right answer. Question number 992. In a bailable offence, the bail is granted as a matter of right by the police officer, by the court, both A and B, either A or B. Correct answer is option C, that is both A or B. Question number 993. The term bail signifies the conditional release of an accused or arrested person by the police during investigation but not by the magistrate during inquiry, magistrate during inquiry but not by the court during trial, court during trial but not during revision, police, magistrate or court during investigation, inquiry or trial. Here correct answer is option D, that is police, magistrate or court during investigation, inquiry or trial. Question number 994. The bail is rule and jail is exception. This rule laid down by the Supreme Court in option C, that is Motiram versus State of MP. Correct answer is option C. Question number 995. Where a person is unable to give bail within dash of the date of his arrest, it shall be a sufficient ground for the officer to the court to presume that he is an indigent person. Option A, week, option B, month, option 2 weeks, option D, 3 months. Here correct answer is option A, that is a week. Question number 996. For the purpose of section 436 CrPC, a person arrested shall be presumed to be an indigent person if that person is unable to give bail immediately after his arrest. Option B, presumed to be an indigent person if that person is unable to give within 1 week of his arrest. Here option B is the right answer. That is presumed to be an indigent person. Under section 436 CrPC, a person arrested shall be presumed to be an indigent person if that person is unable to give bail within 1 week of his arrest. Question number 997. Section 436A of CrPC provides for grant of bail to an accused pending trial if option A, he has undergone detention for 1/4 period of the imprisonment is specified for the offence of which he is being tried. Option B, he has undergone detention for 1/3 period of imprisonment is specified for the offence of which he is being tried. Option C, he has undergone for 1/2 of the period of imprisonment is specified for the offences for which he is being tried. Option D, A and B both above. Here correct answer is option C, that is he has undergone 1/2 of the imprisonment specified for the offence for which he is being tried. Question number 998. Section 437 of CrPC deals with, here correct answer is option C, that is bail in cases of non-bailable offences. Question number 999. In case of non-bailable offence under section 437 of CrPC, the magistrate can release the person and produce him on bail if the offence is punishable with imprisonment up to 10 years, if the person does not appear to be guilty of the offence, punishable with death or imprisonment for life, if the person is not previously convicted of a cognizable offence, punishable with death or imprisonment for life or imprisonment for 7 years or more, and all of them. Here correct answer is option D, that is all of them. Question number 1000. Which of the following is not correct regarding the provisions of bail in case of non-bailable offences? Option A. Bail may be granted if the court concerned comes to the conclusion that prosecution has failed to establish a prima facie case. Option B. Bail may be granted if the court is satisfied that in spite of the existence of prima facie case, there is need to release such person on bail in view of facts and circumstances of the case. Option C. Bail cannot be granted to an accused who may be required for being identified witness during investigation. Option D. If the offence is punishable with death or imprisonment for life, no person can be released on bail without giving an opportunity of hearing to the public prosecutor. In question number 1000, here in this case, it has been asked which of the following is not correct regarding the provisions of bail in case of non-bailable offence. Here option C is the right answer because it is not correct in relation to non-bailable offences. Option C here will be the right answer.